Welcome to Empire Mock Trial's pre-trial evidentiary argument instructional video. My name is Justin Matarrese and I am the Executive Director for Empire Mock Trial. I am honored today to be joined by three very special guests. Judge Pamela Chen of the United States District Court for the Eastern District of New York, Amanda Tuminelli, who is an associate attorney in New York City, and Lars Hulsebus, who is also an associate attorney in New York City. Lars and Amanda were actually teammates on the Georgetown University mock trial team and won the 2013 law school mock trial competition. So they are law school national mock trial champions, and we are very excited and honored to be joined by our three guests today. So today we are going to discuss how to prepare an oral argument. And I'm going to start with Judge Chen and talk about, from a big picture perspective, why do we have oral arguments? What's the purpose of an oral argument?
Well, from my perspective, the reason to have oral argument after a judge has reviewed the written submissions is to clarify or amplify what's in the litigants' briefs, and also sometimes to point out something I may have missed in reviewing those briefs. So it serves all of those purposes and really helps to give a theme in many ways to the arguments on a particular side.
And Judge, how often would you say you grant oral argument?
Well, my practice is to grant oral argument where I feel there's a need to achieve some of those things. I don't grant oral argument for every single case, but some judges do, actually, because they find that it fulfills all of those needs and it's very helpful to them. So it varies from judge to judge.
So I want to talk now about how to structure and prepare an oral argument. I know it's a little different than what students are used to preparing, in particular at the high school level. How can the motions in the briefs be useful to the students as they're preparing?
Really, all of legal argument is taking the facts that you're given and marshaling them, putting them with what the arguments you want to make. So this fact helps me on this point, this fact hurts me on this point, how do I deal with that fact? So that, I think the briefs have already done a lot of that for you. At the very least, they're going to provide kind of a basic roadmap of how to align the facts with your arguments.
Great. And Amanda, how did you structure your oral argument for today?
So because of the format that we're working with, I made sure that I had a very solid 3-minute portion, which was less outline and more just actual scripting of what I wanted to say in the ideal world. I'm not sure that I'll stick to that 100%, but I did write it out. And then I followed that by 3 separate points that I wanted to make, and in very typical outline format, put the cases underneath the points I wanted to make that I actually want to cite, how I would rebut cases that Lars might use against me, and this way I made sure I had a clear roadmap with big, good headings.
Judge Chen, when an advocate is presenting to you, I imagine you question them.
I do.
Okay. How would you recommend that students prepare for those types of questions? How can a student predict or even try to predict what type of questions could be asked?
The best way to do that, after you get done putting together your own arguments, is obviously to pretend you're the other side. And I'm sure that all of you, as former mock trial competitors, have done this. You basically assume the other role and you make the best arguments on the other side. And that's really the only way you can anticipate, is you take on that role. And the key is to focus on the worst arguments, the most vulnerable points in your particular side, and come up with the right answer for the judge.
Great. Lars, does that sound like how you prepared for today? Is there anything else that you did?
Absolutely. I think really the best way to get at what questions you might get asked is to work with the other members of your team, work with your teacher or your attorney coach, and just all try to brainstorm what questions am I going to get asked, and not only the questions, but what is the other side going to say to try to poke holes in what I've just argued. Because you'll see when Amanda and I get up today, hopefully I've tried to predict in my notes already what I think she might argue, and whether I'm right or wrong, at least I'm thinking in the direction of here's how I might try to rebut what Amanda's going to say.
Great. Judge Chen, the students, as they're reading through the motions, will see that the advocates the case writers, included particular pieces of case law and quotes from cases in the motions. Do you find it to be an effective practice for a student, for an advocate, to present particular portions of case law and quote from opinions as they're advocating to you? Is that effective, or would you try to avoid that practice?
I can't categorically say it's good or bad to quote from cases, but for me at least, it's more often than not the case that a quote straight out of a case is going to be useful. Mostly because it doesn't often work out that the case fits perfectly with whatever proposition you want to make.
Amanda, do you have any similar experience? How do you use case law when putting together your outlines?
So I would begin, as Lars said a moment ago, by trying to read through all the cases, and I try to identify first what cases are best for me and what cases are not good for me, just categorically. And then for the cases that are good for me, I list out the factors for what constitutes custody, what constitutes interrogation, what constitutes the public safety exception. So for each case, I would write out the factors that I think are the reason that the court held that in that case somebody was in custody or somebody was interrogated. And then I try to say these are the factors that are similar to the case before me. These are the factors that are different that I might have to explain away. So my outline has a little case brief for each case that I want to use, and then each case that I think I might need to address.
Justin, I want to qualify my answer earlier, and partly in response to what was just said. I do think that there are times when you want to quote a standard, for example, out of a case, because that is going to be the linchpin of your argument. So here I think there's language about a reasonable person's perspective on whether they felt they were in custody or something to that effect. There it makes sense to quote the standard from the most authoritative source that you have to establish that that is the framework that we're operating under. And that would be a good use of a quote.
But it wouldn't be effective to read a paragraph of a Justice Kennedy opinion.
Highly ineffective. Do not do that. Plus, I think when people tend to read, they tend to be more monotonous, and people naturally lose their focus on whatever's being said. It just happens.
It's good that you brought up reading, because I wanted to talk about how to use notes, or whether notes should be used in an oral argument. We all have seen mock trial rounds before. We know that oftentimes they're a bit showy, a bit theatery. So in thinking about how to use notes effectively in an oral argument, or whether notes should be used, Amanda, do you have any advice for the students?
I'm going to have notes with me. I think that it would be, in a pretrial motion context, it would be foolish not to have notes in front of you that at least have what we were just talking about, the cases that you might want to use and the factors in those cases. I think that it's a good idea to memorize the portion of time that you're not going to be uninterrupted, that you will be uninterrupted for. But then after that, I think that you should use your notes as seamlessly as you can. So, you know your big headings, you know the points you want to make, and when you need to glance down to remember a case name, or to remember that all the fact that you actually say out loud all the factors, that would be how I would use my notes.
Lars?
Yeah, I think that's exactly right. And I think maybe your prayer at the end, but the rest of it, you should just make yourself really familiar, get ready to answer the questions, and have the notes to help you when you need them.
Let me add to that. I think this is where there's a difference between mock trial, where you do openings or closing, and even those are jury addresses or judge addresses. It's not the same thing as doing an oral argument, where you really have to be interactive. Because when you're giving an address to a jury or to a judge, nobody's interrupting you. So in theory, you could script the whole thing and read it if you wanted to. You can't do that when you're having an oral argument, because nobody's going to be following your script with you, and there are going to be questions lobbed in the middle of your script that will take you outside of it, as was just said, and you'll get lost. So you shouldn't do that.
One thing I'm curious about is whether the practice of using some type of case theme is effective in an oral argument, or a theme to the oral argument. That's a very popular tactic in both mock trial and trial practice. Judge Chen, do you have any guidance for students?
It depends on the setting. I have found in appellate arguments, which is different than what we're doing here in front of a judge on a specific issue, themes can be good because you're talking about bigger legal issues sometimes. I think they're less effective in a situation like this. You may have one sentence which simply says something catchy. For example, that there's no way a 12-year-old could possibly know that in a locked room or a closed room, you know, with your principal and a police officer standing over you, that you were free to leave. You could do something like that. That's a theme in a way, but it's not the same kind of theme you would do in an appellate argument, which talks about, for example, bigger constitutional issues or things like that. So I think it's less effective in this particular setting, or it's harder to craft one that is in fact specific.
Amanda?
I don't know if you agree with that.
Yeah, I do agree. I think that the judges you get are varied. So you might have a judge that tolerates theater and really enjoys it. And this is, you'll see this throughout the whole mock trial world, right? So there are some judges that love the dramatic openings and love the flowery language. And then there are judges that do not want you to instruct on the law in opening and get really mad at you when you know, make it theatrical. So I just would err on the side of caution here and not incorporate you know, the repetition of a theme throughout the argument. I think you could introduce the theme. You might be able to say it once, but not if it's the kind of theme that's a triplet, or if it's the kind of theme that you know, rhymes, or you know, something like that. I would avoid that. You're talking to a judge, not a jury, and you should keep that in mind.
Let's now talk about the actual argument itself. So how do you begin your oral argument? Amanda, what will you start off with?
I mean, you should begin by saying what you're moving for, and tell the court what you're asking the court to do, and then give a basic summary of the facts. And I think that's really the part where you get to be a little creative while sticking to the facts, because you can present them in the way that you think is strongest for your case. I'm sure that I will present facts differently than Lars will. For that 3 minutes of uninterrupted time, you want to be putting your best facts and your best arguments forward before you get interrupted. And then after that, you get ready to transition into legal discussion.
So you spoke about presenting the facts, but I'm sure some students are wondering, well, I only have a limited amount of time. How many facts should I present to the court? Right? How deeply into the law should I delve? Judge Chen, do you have any guidance for students as they are trying to figure out how much of their argument they should spend summarizing the facts and the law?
So your question relates to real life, but it's probably more pertinent in this setting where you know you have a time limit. You oftentimes don't have a time limit in front of a judge in a real case like this. But the key, of course, and you do this as part of your process of preparation, is picking out the key facts that you need to make sure the judge remembers and knows and remembers, and the key legal principles that apply to those facts. And when you distill it down, you usually can get your key facts into a 2 or 3 minute presentation, I think, quite effectively. But it's the same as, it's sort of a extension of what you've already been doing through your brief writing, which is identifying, isolating, and focusing on those facts you need to win that are the most persuasive. And if you have the luxury of some additional time, trying to anticipate what the other side's going to say about any of those particular facts or other facts.
And I would just add to that, I think it's a fluid process, right? I don't think that you write the facts in one sitting and then you write the law in another sitting and then that's it. I think that you're writing what you're going to say in your legal argument should inform what facts you put in the beginning. So, I will start by writing the facts that I think are important, and then I go and I read the cases and I'm like, oh, I need to say this earlier. I need to make sure that we're clear on this point, that this happened. So I think it's a fluid process. You can't just write it beginning to end.
Lars, we talked before about preparing an outline rather than a memorized speech. What happens when you are asked a question by a judge that you have not prepared beforehand? How do you go about answering that question? How do you go about staying composed while answering that question?
It's tough. I mean, once you're actually in that situation and you get a question that you haven't prepared for, is just take a deep breath. I think time always passes way more quickly whether you're in a mock trial or an argument. You think that any silence you have is just an eternity, and it's not the case. You need to just take a deep breath and think about it. By this point, you will have been applying your logic to the case for weeks or months, and your logic will be really attuned to the facts of this case. And so just give yourself a moment to let it work. I think, hopefully you come up with something. The most important thing to do is to maintain your credibility before the judge. So if you don't know the answer, I think if you honestly don't know and you can't come up with something, the best thing to do is to say, I don't know, as opposed to just give the judge the impression that you're blowing her off and not going to answer the question. I think you want to maintain your credibility, show that you give yourself some time to think, and then if you can't come up with anything, it's not the end of the world.
You can say, Your Honor, I'll do some research on that point and submit briefs on that.
I like that tip.
Yeah.
Amanda,
that's what you would say.
That's exactly what you would say in real life.
Amanda, what happens though if say you're presenting your argument, and in this case you are, in your mind, you're supposed to be addressing the custodial interrogation issue, and then Judge Chen begins questioning you on the public safety exception, and you're not interested in talking about that right now, right? What happens if Judge Chen says, well, I'm interested in hearing about that now? What do you do?
You're interested in whatever the judge is interested in, first of all. So you don't say, well, Your Honor, I'm not done on my point. You can't practice every moment of what's going to happen, but you know where you need to go, and that's why you've got the outline in front of you. And if you really can't think of an organic way to transition, you can just say, Your Honor, I'd like to address the public safety exception now, and then move on to that.
I would say, in addition to, with regard to your question about what you do if the judge asks you about something you hadn't planned to talk about or hadn't planned to talk about for a while, going back to what Judge Chen said at the beginning, this whole oral argument process is to help the judge, and so you should welcome that opportunity to know what the judge is most concerned about. Like you can imagine how helpful it would be if you're giving a closing argument to a jury and the jury could raise their hand and say, I'm really not sure about that fact you just told me. Could I'm not buying it. That would be immensely helpful. And that's basically what you're getting an opportunity to do in this case, is the person who's going to decide what happens to you is going to tell you, in essence, this is what matters to me, and you better convince me on this point.
Judge Chen, do you have any advice for students about how to seamlessly transition back to an argument once they have been questioned by the judge? Because I think the fear is, and I did high school moot court, and this is in law school, this is the fear that I had was, well, I just answered the judge's question, now I'm kind of lost and I'm frazzled, like, what do I do?
Well, I mean, I think what was suggested by Amanda a minute ago is perhaps the best way to do it, and I consider it actually seamless, which is that, and you could add one sentence, which is that if the court has no further questions on this issue, I would like to address the public safety exception. So you could acknowledge that perhaps a judge might have some other questions, make that invitation, when in your mind what you really would like to do is move on. But that really is the best way to do it, which is to say to the judge, telegraph, this is where I'd like to go now. I think this is something important. There may be a circumstance where one flows, the answer to the last question flows to the next topic, but in this hypothetical, I don't think it necessarily works, and oftentimes it won't. There's nothing wrong with saying, this is what I'd like to talk about now. Judges really aren't offended by that kind of signal. And if they stop you, then you go where the judge wants to go.
So would you say then that the roadmap the student provides up front is something that they don't necessarily have to stick to?
Absolutely. You should not be wedded to your roadmap. I mean, just as was being said by Lars, the purpose, again, of oral argument is to answer the judge's questions, the fact finder or the decision maker's questions. And so if that person is signaling to you they're interested in something else, that's where you should go. Now, that being said, if you, because you know the case probably better than anyone, thinks there is an important point that even if the judge doesn't realize it yet, is key to the case, and you feel like you can't sit down without making that point, you can say, there is one other point that I think is important to address. And again, signaling very politely to the judge, this is something I think you should pay attention to even though you haven't asked me about it. Perfectly fine as well.
And I think students should also be prepared to not have a judge as reasonable as Judge Chen and have a judge say, I'm not interested in that. Or, I agree with you, it's custody, tell me why it's interrogation and why the public safety exception doesn't apply. So I think that you should not be offended by that and not take that personally and be able to say, okay, and use that as an opportunity to talk about what the judge wants to hear about.
Something you just said about not being offended and taking it personally, I think is going to be really important for students to keep in mind. That just because If a judge is asking questions and interrupting the student, it doesn't mean that the judge is disinterested in what the student has prepared or doesn't value what the student has prepared. It just means that the judge has their own questions, the court has its own questions that it wants to pose to the students.
In terms of scoring points, I think in a pretrial style argument, you can, I think, be really impressive and score a lot of points by showing that you're willing to respond to what the other side has already said or what the judge is going to say. So, you know, you'll see when we do our argument, I have a particular roadmap that I intend to follow, and I have a lot of, you know, little bits that I want to say in my argument. But there's a chance that Amanda might frame her argument in such a way that I see an opening that, you know, this is the thing I want to address first, both because I think she's made it more important and because it'll just look really impressive if I can start with whatever it was that was her weakest point. And so you should have your roadmap prepared, but you shouldn't be afraid to deviate from it if you know, can make yourself look more impressive and show that you can think on your feet.
Amanda, how do you go about closing an oral argument if you have the time to close with something nice and neat? What do you say? How do you close?
Right, so that's an if, right? So, I mean, you might just be ending a question and you might have 10 seconds to wrap up what you're saying, and I think that you need to I mean, I have something on a piece of paper that, you know, in an ideal world I would get to say out loud. But you should be able to distill your argument down to a sentence if you need to. And that's the sentence that you close with, followed by the prayer, which is, you know, we want to move to suppress in this case. So if you can, and you should be able to summarize your argument in a sentence, that's what you default to. If you're given more time, then you go through and once again hit on the facts that you think are the most important for your argument and the strongest and in your favor. I would not do the mock trial thing of posing a question to your opponent.
Would you suggest that students reserve 2 minutes for rebuttal, or do you believe they should use the entirety of their time on their initial argument?
Oh, you always want the chance to speak last. You never forego that opportunity. So I would say you should always reserve 2 minutes, even if you don't use those 2 minutes and you end up with a minute and a half or a minute, and we've all seen rebuttals that have been 20 seconds, right? If you have the opportunity to leave the judge with the last thing being said is something in your favor, you take that opportunity.
Judge Chen, would you agree with that advice?
Oh, absolutely, yeah. You definitely want to have your words be the last ones that are ringing in the judge's ear as the closing comes.
Great. Well, Judge Chen, Amanda, Lars, thank you so much for taking the time to join us today. The students are very lucky to hear from all of you, and they will be, I'm sure, very excited to see your oral argument in just a few minutes. I know I'm excited to watch.
We're here for oral argument on defendant R.J.N.'s suppression motion. Are the parties ready to proceed?
Your Honor, the government is present, ready to proceed.
Defense is also ready to proceed, Your Honor.
All right, we will begin with the defendant because it is his motion.
Thank you, Your Honor. Before we begin, may I bring to the court a copy of the exhibit in this case, which is a copy of the tweet at issue and the transcript of the interview.
Yes, that would be very helpful.
Opposing counsel has already seen this exhibit, so I'm now just going to approach the bench.
Thank you. You may proceed.
Thank you, Your Honor. We're moving to suppress all statements made by my client, R.J.N., a 12-year-old boy who was questioned in a closed-door room by an armed police officer without his parents present and without any Miranda warnings issued to him. The public safety exception does not apply here to excuse the officer's conduct. I'd like to begin by presenting the court with a brief summary of the facts that are relevant to the motion. It's 8 a.m. R.J.N. is sitting in his first period science class. He looks up, and at the classroom door, he sees the principal of his school and a police officer, Officer Finch. Officer Finch is in her full on-duty uniform. She's wearing a baton, and she has her gun plainly holstered at her hip. The principal and Officer Finch remove R.J.N. from class and walk with him to the principal's office. and seat him in a room at a table where they surround him. The two of them, the armed officer, the principal, and the school guidance counselor, Ms. Clearwater. They shut the door. His parents aren't there. It's 3-on-1 for the next 15 uninterrupted minutes. Officer Finch does not say to R.J.N., "You don't have to answer my questions." She doesn't tell him that he is free to leave. She doesn't ask him if he would like to speak with his parents or if he would like them present. Instead, she sits across from a 12-year-old boy and she interrogates him. First, she shows him a screenshot of a Twitter account. She puts it in front of him on the table and she asks him if he recognizes it. And as the court is aware, the tweet at issue says, "6th period today, get ready to get bombed, hashtag," or Hillcrest, excuse me, hashtag "this is not a drill." So with the screenshot in front of R.J.N., Officer Finch asks him if he recognizes the tweet. And R.J.N. shrugs and he gets up to leave. And this is the pivotal moment, Your Honor. This is the most important moment of this entire interaction. Because when R.J.N. gets up to leave the room, they don't say okay. Officer Finch stays silent, and Ms. Clearwater, the guidance counselor, says, "You can go back to class after you answer Officer Finch's questions, not right then." If R.J.N. felt he was free to leave, it was at that moment that he would have left the room, Your Honor. So Officer Finch again asks him about the tweet that's sitting on the table in front of him after he sits back down, and R.J.N. denies sending it. Officer Finch continues to challenge R.J.N., continues to question him and interrogate him. Then Officer Finch leans in, for lack of a better expression, she gets in his face. She's less than 12 inches away from his face, and then she lies to him. She tells him that she has a record of his text messages and phone calls from that morning, so she can check. She has proof that he was on his phone when the tweet was sent. So after she lies to him, that's when R.J.N.'s face turns red and he wipes his sweaty palms on the front of his shirt because he is scared.
Let me stop you for a moment. You characterize what the officer said as a lie, but in fact it was a hypothetical. Wasn't the question something to the effect of, if I told you that you were tweeting your friends before and after the tweet in question, what would you say? That was the hypothetical. She didn't actually say, "I have them," correct?
Your
Does
Honor,
that make a difference?
I think it does make a difference, and Your Honor is correct that it was stated as a hypothetical, but I think to any reasonable 12-year-old, to any reasonable student, saying to them, if I told you that I had your tweet, your record of your phone calls and text messages, that would be interpreted as, "I've got you." That's a got you moment.
Well, that's my point, though. There's a difference between a lie, which is a statement of an untrue fact, which is what you started off by saying, and posing the hypothetical. If I told you that, what would you say? And this is akin to one of the cases, I think, that was cited by the government, that when it's phrased in a hypothetical, it isn't the same. In other words, she never said to him, "I have your texts," correct?
She did not say that in an unequivocal way, Your Honor, but I think that any reasonable student, any reasonable 12-year-old in that position would have interpreted that, depending on how it's emphasized. I mean, we don't know, we weren't there, but depending on how it was delivered, I think that a reasonable 12-year-old would have interpreted that to mean, "I have incriminating evidence against you." And I think that the purpose of putting the tweet in front of him and the purpose of saying things like that was to elicit an incriminating response, which adds to the custodial setting, which adds to the fact that it was in fact an interrogation.
Mm-hmm. Can I ask you a question? You rely in your brief on the Supreme Court case, get the right initials, JDB, right? That's
Yes.
an important case for you, and you've argued that that sets the standard in a way. But in JDB, the Supreme Court merely remanded the case, making the point that age matters, right? Do you argue that based on JDB, I should find in, as you ask, and suppress, or are you citing some other cases?
Well, partially on JDB, because as Your Honor just said, it says that age isn't a factor, and here I think it's an important factor because 12 is young, but we also rely on NC versus Kentucky, which is a case where the court found that no reasonable student would have felt free to remain silent or to leave in the setting there. And the setting there was actually very similar to the setting here. There was a student taken out of class. questioned in the assistant principal's office with an armed police officer present, and in that case it was actually the principal asking the questions, not the officer. And I would argue in our case it is even more of a custodial setting because it was the armed police officer asking questions. There the door was closed. No one told the student they could leave. No one did even a watered down version of a Miranda warning. And the court found that custody was, the student was in fact in custody, and also the student in NC was 17 at the time. So you can imagine how a 12-year-old would be even more frightened and even more alarmed at what was going on and feel even more pressure to stay in the room.
Well, let me ask you, in NC, isn't it correct though that the circumstances were a little more extreme in that there was a statement made that NC actually was going to be charged criminally, or did I misunderstand that case?
In NC, they actually, one of the issues before the court was that the principal made it sound like there was only going to be disciplinary conduct in the school and not criminal conduct, and it was only after NC confessed to the crime at issue there that the officer then chimed in and said, and by the way, you're going to be charged with criminal conduct. Here, we have R.J.N. sitting with a tweet that, you know, I would argue has equivocal language in it, but it is still, they're implying to him that there's something about a bomb. And I think that it was clear to him that he was in trouble at this point in time.
What about the public safety argument?
So the public safety argument does not apply here. And I think that the most important point to that is that in New York v. Quarles, which is the case that is the most seminal case on this issue, the question that the officer asked in Quarles was designed to address the imminent and ongoing emergency. The question was, where is the gun? In our case, Officer Finch didn't say, where is the bomb? What kind of bomb is it? Can it be detonated? Instead, Officer Finch sat in the room that presumably would blow up if this bomb was actually a threat, and asked him about a Twitter account.
Let me stop you there. They knew at the time that the bomb was not supposed to blow up until noon or so during the 6th period, right? So this officer didn't have the same kind of imminent concern, right? And wouldn't she have to ask the defendant if he actually sent the tweet first to determine if he knew if there was a bomb or not? I mean, wasn't that essential? I agree with you that she didn't ask, where is the bomb, or information directly related to the bomb. She focused on the threat. But wasn't the first step of inquiry to figure out if, in fact, this defendant had sent out the tweet, had made the threat, and had information about the bomb?
So I think that in this case, it would be a big assumption for the officer to make that the 12-year-old was such a mastermind at bomb making that he knew exactly when his bomb was going to go off in 6th period. I think that if the officer reasonably believed there was a bomb in that school, she would have evacuated the school immediately, and the first question out of her mouth would have been, where is the bomb?
But didn't they evacuate the school at the same time he was being questioned?
Not until after he had said to the officer that he sent the tweet. And Officer Finch's questions were designed, they were investigatory. That's the big difference here. And in a footnote in in footnote 8, they talk about, they actually distinguish a case where there were investigatory questions as opposed to questions elicited, trying to elicit whether the emergency could be stopped. And I think that that is the pivotal point on the public safety exception.
But don't you agree that she would have to first determine, meaning the officer, that the defendant was the one who sent the threat? Because he started off by saying it wasn't me. So all of her questions to determine that he was the one who made the bomb threat were geared towards trying to figure out if there was actually a bomb, and if so, where it was. Wouldn't you agree she'd have to establish that first?
I don't agree, Your Honor. I don't agree that she could have taken the time that she took to ask about Twitter, to ask about his friends on the bus, whether or not his friends threatened him, whether or not he has a bad relationship with his friends. I think that an officer who was truly thinking about the ongoing emergency would have gotten in the room and said, is there a bomb in this school, and where can I find it? And I think I think instead she focused on her investigatory evidence of guilt rather than trying to address the ongoing emergency.
That's a curious argument, because clearly she's an investigator who's trying to earn some trust with this young boy during this interview. So starting off by trying to ascertain that it was his account, his Twitter account, would seem to be more successful in terms of an approach than immediately saying, where is the bomb? Wouldn't you agree?
I don't agree, Your Honor. I think that Quarles actually goes directly to this point, and I do want to reserve at least a minute for rebuttal for after the government response. But I think that she, if she truly, and it is an objective standard and not a subjective standard, and we shouldn't, try to get into the officer's mind here, but I think that any reasonable officer in that position would have been thinking about the bomb and would have asked questions about the bomb. She never asked a question about the bomb. Well,
she did at the end, and within 15 minutes or less, she figured out that there was no bomb. Isn't that right?
She took the word from R.J.N. that he did not have a bomb, even though he told her that it was a joke. But up until that point, the conversation was focused on Twitter and not the ongoing emergency. So we would pose to the court that the public safety exception did not apply, did not excuse the fact that no Miranda warnings were issued, and ask the court to suppress all of R.J.N.'s statements.
Okay, thank you. I'll hear from the government now.
Yes, Your Honor. May it please the court. My name is Lars Hulsebus on behalf of the state. I have 2 points today to make in opposition to the defendant's motion to suppress. First, I'll address why there was no custodial interrogation, because there was no custody at the time that R.J.N. was being questioned and then at the time that he ultimately confessed. And then I'll discuss why, even if you find there was custody, the public safety exception to Miranda applies. So first, as to custody. As Your Honor knows, in order for a court to suppress a confession on the grounds that a Miranda warning was not given, 2 elements must have existed at the time: interrogation and custody. And I'm going to focus today on custody. Custody is an objective inquiry, and it contains within it 2 discrete inquiries that the Supreme Court said in JDB was essential. The first inquiry is, what were the circumstances surrounding the questioning? Now, my opposing counsel mentioned some of the facts of this case, but I want to address some of the facts that I think she glossed over. First of all, she said that the first thing that R.J.N. saw, when he looked up, was the officer. That's not necessarily the case, and it's not the only person that R.J.N. saw, because the officer didn't go alone to collect R.J.N. from the classroom. She went with the principal. The principal then escorted R.J.N. back to the principal's office. Some facts about the principal's office. This was the record shows, a large, bright room decorated in school colors with school memorabilia. And I'd submit, Your Honor, that in a middle school, the principal's office is a place that's going to be very familiar to the students. And then counsel said that the questioning was, quote, 3-on-1. Well, if you think about it, Your Honor, there were 3 adults, and 2 of those adults were non-police presences. One of them was the principal, who the student would have known, and one of them was the guidance counselor. Your Honor, I think if most of us think back to our school days or where our kids go to school, we know that the guidance counselor's job is to be the least threatening person in the room. This is the person who wants the students to come talk to them. Now, having looked at those circumstances, the second inquiry under custody is, given those circumstances, would a reasonable person, in this case a reasonable middle school student, have felt that he or she was at liberty to leave? And the key phrase here is freedom of movement. That's the phrase that they use in NC Kentucky, the case that counsel relied on so heavily. They said that custody requires a formal arrest or restraint on the subject's freedom of movement comparable with a formal arrest. And if you look all throughout Miranda jurisprudence, Your Honor, in all kinds of different contexts, you see that the freedom of movement question is asked against a baseline of what that person is used to, their usual freedom of movement. So in this case, we're talking about what is a middle schooler's baseline freedom of movement. A middle school student being in a room, I would submit, with your principal, with the guidance counselor, that's part of your baseline.
I want you to answer the question posed by the other side, which I do find important. At the moment that the defendant says, I need to go back to my science class, the guidance counselor says to him, you can go back after you help the officer, correct?
Yep.
Okay, how is that different than saying, you cannot leave until we get what we want?
Well, Your Honor, I think it behooves us to consider the actual question as it was asked. I have the transcript in front of me. The entire response when R.J.N. gets up from that table is from the guidance counselor, R.J.N., you're not in trouble. Notice there that she uses the words of school. She's not using words that put us into a law enforcement context. She's using words that the student would have been familiar with.
Although, interestingly, that could be construed as a lie. I mean, if you talk about whether the lies were told, he clearly was in some potential trouble, was he not?
Whether or not it was a lie, Your Honor, the fact remains that what we have to look at is whether the student would feel free to leave. And I think the student would feel more free to leave if he's told he's not in trouble.
Okay, well, let's parse a sentence I'm interested in, which is, how does saying you can go back to class after you help the officer not equate to you cannot leave until you help the officer?
Well, Your Honor, I mean, neither of us was there. I think looking at the transcript, it suggests to me, especially the way the guidance counselor phrases it at the end as a question, you can go back as soon as you help her see there's nothing to be worried about, okay. I think this would not have been interpreted by a middle school student as a threat, you must stay here, as we're used to in the Miranda context, you have to stay here and answer us or X, Y, Z will happen. I think this was phrased by the guidance counselor in a way of, we'd like you to stay here and help us.
You mean to tell me, though, that a 12-year-old who's looking at his principal, who is the highest authority figure in the school, an armed police officer in full uniform, and a guidance counselor, when told that, no, sit down, you can go back to class after you talk to us, doesn't equate to that child as, these three authority figures are telling me I cannot leave until I speak to them?
I think we have to think about this in the context of a middle school student, Your Honor, which is what...
12-year-old. You keep saying middle school. We're talking about the youngest student of any of the cases that anyone has cited to me, a 12-year-old.
That's correct, Your Honor. But we're not talking about a 12-year-old who, based on the record, we have to be concerned with being overly compliant. I think there's evidence of that in the record, that this is a 12-year-old who was comfortable with not doing everything that his teachers would tell him to do. For example, if you look at the Twitter, this 12-year-old's Twitter handle is School Sucks 115. If you read the brief that we summarize in the record today, you'll notice that the first two questions that this officer posed that we're supposed to be concerned were so scary to this middle schooler, he shrugged. Isn't
the issue, though, reasonable? In other words, you are introducing some relativity or some individualized inquiry based on this child, but isn't the whole point of our, I'm bad at initials, the JDB case to say that the officers should be using an objective test rather than trying to introduce some of these factors, like judging whether or not a child saying school sucks as his tagline means he's a rebellious young child who can decide he can leave and thwart an armed police officer and a principal.
Well, what R.J.N. said, I submit, Your Honor, is that age, R.J.N. was the first, JDB rather. What JDB said was that you can use age among the multiplicity of other factors that you can use, that this custody test, as the court has said since time immemorial, is objective and taking into account all of the circumstances. And so JDB says that yes, you can consider the age, but you can also consider these other factors. And
well, here's what I'm going to say. I'm going to quote to you from JDB. This is what your argument strikes me as. The purpose of the objective test is to avoid burdening police with the task of anticipating the idiosyncrasies of every individual suspect. But you're arguing to me the individual idiosyncrasies of this child based solely on his tweet tagline. The point is not to focus on the defendant's idiosyncrasies, but rather to focus on the police behavior and what kind of prophylactic rule we should have in place, which is that they should not be interrogating 12-year-olds in a closed room without informing the parents. And speaking of that, what about the fact that the school didn't follow its own policy on notifying the parent, leaving a message even? What am I to do with that information?
Well, Your Honor, I think that information, because they attempted to reach the parents and they just weren't successful in reaching the parents, the record reflects that they called the parent
Why didn't they leave
times.
a message?
I can't speak to that, Your Honor. It's not in the record, so I don't know the answer to that.
Why didn't they wait until they at least contacted the parent and follow their own procedures?
I think the reason is, and this I would say would lead us right into the public safety exception. The reason is because of the risk that was posed by this threat, and so they worked as quickly as they could. Counsel talked about the public safety exception and said, why didn't they begin immediately searching the school? Why did they first ask about the tweets and not focus on the bomb? I think you get a flavor if you read the transcript, Your Honor, of how short this really was and how fast it happened. And in regards to the public safety exception, I want to just highlight the timeline here. The timeline that's in the record, Your Honor, is that at 6:52 a.m. the tweet's posted. 30 minutes later, a 911 call is made at 7:22. 23 minutes later, the officer arrives, and at 8 o'clock, the interview is over. Right, so in the space of between 7:22 and 8 a.m., 37 minutes had passed, and what we know from the record is that by the time we know that the search dogs were in and the students were being evacuated from the school by the time that R.J.N. was handcuffed sitting in the office. This whole thing, the fact that the government says they didn't act as if the threat was immediate enough, it took 37 minutes.
Well, does it matter how the police acted? Aren't I just supposed to look at whether or not there actually were emergency circumstances? In other words, do I care whether the officer did the best job she could have in getting to the information or moving quickly enough?
No, Your Honor, and Quarles says that this exception does not depend upon the motivation of the officer, but I think the fact that from the facts in the record the officer behaved reasonably is important to Quarles. And I think especially, the line that seemed to be set in Quarles from Judge Rehnquist's opinion was between questions necessary to secure their own safety and questions designed solely to elicit testimonial evidence. And I would submit, Your Honor, that if you look at the record here, the transcript, you'll see that the officer was getting very quickly and very effectively to the fact of whether or not there was actually a bomb.
So you agree with me that it was essential for the officer to first establish or get the child to admit that he was the threat maker?
It was absolutely essential, because otherwise there'd be no way for the officer to know whether this person had any authority to speak on the matter of whether there was a bomb.
So then the obvious question is, why, after he said there is no bomb, did she not test his disclaimer, especially given the fact that he had lied to them at the beginning of the investigation, if in fact there was a true emergency that was being dealt with?
Well, I think the point you just made is exactly why they didn't wait and try to test his statement that there was no bomb, because he'd already lied to them several times in the course of this short interview. Once they knew they had the right person, I think then they knew this had to be could be a credible threat, and at that point they had to move to searching the school and evacuating everyone. Your Honor, for all these reasons, the state would respectfully ask you to deny the motion to suppress. As the Supreme Court has noted a number of times, the ready ability to obtain uncoerced confessions is not an evil but an unmitigated good, and in this case the unmitigated good was extremely high, as the possibility of not getting this confession was that there could be serious damage caused to the school and the student body.
Thank you. Rebuttal.
May I proceed?
Yes, you may.
Your Honor, I would just very quickly like to make the point that in response to what opposing counsel said, that timeline is a long time for a police department who truly thought that there was an ongoing emergency. And I think this court knows, as the police department knows, that people aren't always serious about what they say on social media, and there wasn't an ongoing emergency in the police department's determination. The exception does not excuse the officer's decision not to Mirandize R.J.N., and we respectfully ask the court to suppress all statements made while he was in custody.
What do you say in response to opposing counsel's argument about the officer correctly didn't believe R.J.N. when he said there was no bomb, and so therefore now they knew they had a potentially credible threat? That seems perhaps backwards to me. In other words, isn't that the moment you would argue that they should have started drilling down a little bit more to test whether or not he actually believed there was he actually planted a bomb? I
completely agree, Your Honor, and I think that speaks to the point that the police department never thought there was an ongoing emergency. They didn't send a bomb squad. They sent one officer by herself to a school. If they truly thought there was a bomb in the school, if there was truly an emergency, then I would imagine that the response would have been as if there was an emergency. I think this was a retroactive argument created by the government. I don't think this was what was on the officer's mind at the time, which I know is not the inquiry. However, I think it informs the way this court looks at the situation. I don't think it was an ongoing emergency. I think that she was trying to get that to the bottom of a prank joke on Twitter.
Well, you're trying to thread a needle here. You're saying, I don't need to consider what the officer's motives were, but I gather you're arguing that whether her actions were reasonable or not is something I should consider, and whether in deciding that the public safety exception should be applied so as not to suppress this evidence?
So, well, yes, in favor of suppression, Your Honor, but...
I'm sorry, so as to
yes.
suppress the evidence?
Yes.
Okay, thank you very much.
Thank you.
I would say both advocates were excellent, better than most lawyers I see in my courtroom, I will say that. So let me talk a little bit about structure and style, because I think that's the most important thing. Amanda, I thought your opening was terrific because you had great poise, demeanor, and what I thought was great also is that you put the facts into the very first sentence almost, which was closed room, 12-year-old, police officer with a, I don't know if you mentioned gun. You set the stage very well, and you brought out, we talked about facts, you emphasized those facts that you wanted me to have at the top part of my brain when I'm thinking about this fact pattern, because those were important for you. So I thought that was an excellent way to start. You used your 3 minutes very well. There were some phrases that you used that I thought were so terrific. 3-on-1, which of course made your opponent have to address it for the next 15 uninterrupted minutes. Very good use of words to emphasize points. Interrogate was a very good word, of course, and then you signaled the important moment, which I happen to agree with. At the moment the young child said he wanted to leave, he was told he could only after he helped, and that to me was a significant fact. So I thought you pulled out exactly the fact that I needed to know about free to leave. Says it all, and I thought that was really effective. Now moving on to the part where there's more question and answer. The only comment I would make, because I thought your answers were really good, you knew the record well, you focused on the important cases and the facts, was you went too fast. And the reality is I had no trouble understanding it, so it wasn't too fast in that regard, but in a real courtroom, and for some judges, that speed would not work because you have a court reporter, and the court reporter would have stopped you, and I would have stopped you for the court reporter's sake. So you have to be conscious. I realize that you have a time limit here, and that was your concern, but you're always going to feel that way in court, and in this exercise in particular, you have to slow down. One thing I've learned from sitting on this side of the bench is people actually listen more if you speak slower, because they emphasize on they hang on every word you say. Too slow is not good, but I have discovered that people who speak fast, it's almost like a wall of sound, and at some speed, people stop listening. So you have to practice doing that in front of a mirror or watch the videotape to see. Other than that, I thought your answers were very good. One thing to pay attention to is if a judge is actually giving you something helpful. I can't remember, at one point I think I was trying to give you something helpful, and I think you were resisting me, wondering. It wasn't in the rebuttal, but it was something during your argument. Your answer about the public emergency exception, that's something that you would have probably had to think about a little more, because you were stuck between saying, well, the officer's subjective intent in her interrogation doesn't matter. So then what? What am I to take away from the fact that she didn't seem focused on the bomb emergency? And that's where you have to go back to the case law, which is that what she did wasn't reasonable. And the point of this is that it's supposed to be a prophylactic rule to prevent officers from using this exception to build cases. And I think you did that, but I think that was a little harder argument. And so if I were you in your prep, knowing that that's a harder argument, I might have spent more time. And unfortunately, I didn't give you much chance to do that in the argument.
Judge, when you say prophylactic rule, what do you mean?
Well, so obviously the purpose of the Miranda suppression rule. So Miranda exists to say everyone has a right, and the suppression comes along to prevent officers from doing bad things and trying to get confessions out of people without telling them their rights. And so the suppression rule is meant as a prophylactic against bad police behavior. And so emphasizing that part of it again is it's trying to parse a very fine intellectual line between the bad motives maybe of the officer. How does that really relate to the test? And I think that was a little murky in terms of your argument. And it's hard in the case law, but I think I would focus a little bit more on that. Now, turn to Lars. Your opening was quite different, and it was an interesting contrast, I thought. Maybe as the government representative, it's appropriate. You came off as more reasoned and less emotional in some way, which is appropriate, I think. Less appealing to me about the factual circumstances and more about the law. I thought it was good. I don't know, though, if I might not have started off with something a little bit more responsive to hers. It's a thought you might consider. I think you should have a prepared opening, but you might use your 3 minutes uninterrupted to be able to say, I'd like to start off by responding to whatever you think the worst argument. It's a strategic decision you could make. But when you're in that position, I think that wouldn't be a bad way to go. I realize this is a bit of an exercise. Your demeanor is terrific. You speak at a perfect speed all the time, even when answering questions. You have great poise, as does Amanda. You come off as very, thoughtful, reasoned, and that's good because the judges like to think you've done your homework. And I thought you were excellent. You did what we've discussed, the perfect segue to the public emergency exception when you felt that you were not winning, judging by my tone. The custody interrogation argument, you quickly found your escape hatch and said, that's a perfect segue to and you used it perfectly because we talked about time, right? And you marshaled your facts extraordinarily well on the timing. And I think the only thing I would suggest is you should listen a little bit more to the questions I ask of the other side, because sometimes I was obviously saying things that could help you. And it's nice, judges like to hear you say, just as you said earlier, Judge Chen, pats their ego, it shows you're listening to them, but it's helpful and it shortcuts through it, which is, yes, I agree, that's right. You should ignore whatever answer she gave you, you have the right answer, right? So reassuring to the judge that they've got it right. But your answers were spot on and you focused on the most important facts, the best argument you have, and quite frankly, perhaps a winning argument. So I thought you did a great job. Great job with your closing one sentence. Good job with yours as well. I thought you were both excellent. So.
Thank you.
Thank you. Amanda, did you, in thinking about your presentation today, is there anything in particular that you wish you would have done differently?
Yeah, so in reflecting on the public safety exception argument specifically, I do think that I needed to have thought about how I could have stated my argument more clearly at the outset. I had all these bullet points and I had planned to, I guess, have more time to get through all of them, and I wish I had more concisely formulated the thought in my head so that I could have presented it in a much more of a soundbite kind of fashion.
So you're saying present it more in a soundbite fashion up front?
Yes.
And then Lars, what about you in thinking about your presentation today?
Yeah, I mean, first of all, I wish I had done what Judge Chen suggested, which was start as opposed to with what I had prepared. And it's funny because I said this earlier on, that this is what you should do, and then I didn't take my own advice, is, start by rebutting the weakest point made by my opponent. I think I was thrown off there because I had this, I wasn't prepared to stick to an entire script, but I wanted to stick to my 3 minutes that I had planned, and I didn't let what happened ahead of me push me off of that 3 minutes, and I wish I had. So, I think in terms of what that translates into advice for the competitors is, be prepared to speak three minutes on, or 2 minutes, or however much it is, on a couple of different topics that might come up. And the other thing is just, of course, I've done this kind of an argument competitively before with different time formats, and no matter how much time you get, you always leave stuff on the table that you wish you had said. There were things that I wrote down, as Amanda was saying. I wanted to respond to the NC versus Kentucky case in a variety of ways. I wanted to address what she was saying about the public safety exception in a variety of ways that I was, jotting notes in my script, and I just never got to them. So I guess if I was going to distill that into some kind of advice, it's that you just have to forget. If you're going to do this a bunch of times, you got to forget what just happened to you the previous time and just moved on. And hopefully next time you get to use your beautiful rebuttal point that you didn't get to squeeze in.
Yeah, I think what this shows is you could so easily get derailed from your points because you have a judge who insists upon asking you questions that you may not think are that important, or that you hadn't quite you weren't quite prepared to answer that particular version of the question, and then it's hard to get back to the points that you want to make. That's the nature of oral argument, unfortunately, and it's frustrating, I know, for you not to be able to make all of those points. I think you both did a very good job, though, of answering the questions. And if we all subscribe to the theory that what matters most is what I want to know, you both did an excellent job, I think, of responding to what I wanted to know, and I think it's good. And you certainly got in your, I have to say, very well, your public emergency, argument, which was really your winning one. And in that regard, I will say this, Amanda. One other thought is, even though as soon as the 3-minute time limit was up, I decided to start asking you questions. You might have structured your argument, and I don't know what else you had after that, to get to the public emergency exception very quickly, because especially if you notice that I was with you on the interrogation, although I don't know if you could tell, just in your own scripting, and I don't know what else you did, I would have gotten to that quickly, because that is the one thing you needed to address. So
there were a couple of points that I wanted to make, things that I think we forgot to cover before. One is the importance of being conversational in an oral argument, and I thought both Amanda and Lars did a very nice job being conversational when presenting their oral argument, because it's supposed to be more like a discussion with a judge. Yes, in their mock trial competition, the jurors will be in the room because they are scoring the pretrial argument, but of course in real life they wouldn't be there. It's just a discussion with the judge. So I think they both did a fantastic job being conversational, which is important. Then I wanted to ask Judge Chen about, just revisit their introductions, because I found them to be so different. How Amanda presented almost like a mini opening statement and ran through some of the facts of her case that were compelling. I looked at the timer and she spent almost 2.5 minutes on almost a dramatic mini opening, which I found to be effective. Whereas Lars stood up there, was a bit more clinical in his approach and said, these are the 2 things I'm going to address, and I'm going to take them in order, and then so that put that roadmap up there. I thought Lars's roadmap was clear, whereas Amanda spent more time appealing to emotion, and the roadmap wasn't as clear. So I wanted to get your thoughts on that more.
Yes, I have to say I would not roadmap an argument in this setting, because the judge knows what the issues are. This is not like a trial where you're trying to say to the jury in your opening, here's what you're going to see. So that's why I said I might have switched tactics and started off with either something pithier and responsive, potentially to the best arguments that the other side was making, and to what you may have heard me saying, which is, you could have even started off with something like, Your Honor, you have it exactly right when you said X, Y, and Z, or something like that. But I would definitely favor, quite frankly, the opening that you did, because very effectively, and it's really good to use your words as you did, which is you packed a punch with every single word. So in 2 minutes, you pretty much painted the picture I needed to see, at least on the interrogation issue. Now, interestingly, you chose not to discuss at all the public emergency, right? That's a good choice, because I think you had me in your corner, and then it's sort of a question of the government. I think, as we all saw the fact pattern anyway, having to try to save it from what was probably sloppy police work in a way, or the school running roughshod over this kid's rights. So I would definitely go with that. And even on the government side, I would come out fighting a little bit more. You were a little bit too patrician, too sort of scholarly about it in a way, because this is a bit of a street fight more so than if you're in front of the Court of Appeals, or even if you're giving an opening to a jury.
Would you say, as a general rule, the moving party should be a bit more dramatic or at the very least storytelling, whereas the party that's responding should be more responsive because they're coming right after the moving party?
It's a good question. I mean, we're talking about facts here. This case is going to rise or fall on the facts and which ones the law sort of recognizes as appropriate for whatever the relief they want is. So I think this is a situation where you do have to talk a little bit more about the facts. I think a response from you could have been something more to the effect of, this was a situation where a 12-year-old boy who had, as you said to me, written school sucks, and basically said he wanted to leave, at some point decided that he got caught, right? You should have maybe portrayed a slightly different spin on it, and the law does allow that, right? So long as he wasn't in custody and he was free to leave. And then that's how I think you might have told the story slightly differently, but weaving in the law. And then get to the public emergency exception immediately, which is that even so, this was a situation. And that was your most dramatic fact. You had a great fact, which is a school with 700 children could have blown up if this law enforcement officer hadn't done what he did. And that, maybe you would have even started with that as your opening line.
One final thing I wanted to address, because I feel like this could absolutely come up during a pretrial argument, is that, Lars, during your argument, I thought it was very clear how Judge Chen felt about the issue and the issues, the custody issue. Judge Chen did not hide her feelings at all, and she grilled you a lot on that issue. So, one, I think, Judge, you would agree, Lars kept his composure extraordinarily well.
Absolutely.
I mean, was not flustered at all, answered clinically and professionally. You would.
And he didn't seem bullied. That's another thing. Don't be afraid. Forget about offended. Don't be afraid. Then to stand your ground.
Absolutely, and because I can see that happening to students, and then students feeling like, well, I'm losing this, so I'm going to
go home.
I'm going to go home now. Yeah, whereas Lars rebounded incredibly well and finished his argument well. And last but not least, Judge Chen, would you have suppressed?
That's a good question. I will tell you, Lars actually convinced me a little bit by the end about the public emergency exception, but I probably would have suppressed. You know, it's interesting because ultimately we're talking about evidence that's used to convict somebody of a crime, and ultimately, while I understand the exception, it seemed to me here they dealt with it without having to interrogate this young kid by searching the whole building and the school, and they did, you know, so it's a little bit of pragmatism, but ultimately I do feel like what the police did here was, and the school, quite frankly, with the complicity of the school, was not good. I would have suppressed.
Well, Judge Chen, Amanda, Lars, thank you so much for your time. The students are really fortunate and privileged to have the opportunity to hear from you, to learn from your insight, and to watch the oral argument. I'm sure they will enjoy it as much as I did. Timekeeping. So thank you guys so much, really.